This meeting is now being recorded.
So thank you very much for being here today, both Dykema lawyers and our guests from outside. I am pleased to turn things over to Heidi Naxo, who's going to talk to you about motions to terminate for personal protection orders. Heidi?
Thank you, Morgan. Today we're going to be talking about how to handle a motion to terminate for a personal protection order. And I'm going to be speaking, kind of out of two sides, with two audiences in mind. Today, I'm going to be talking to those of us who are volunteering for the Impact Project for Detroit, which is the two halves of a different coin. The collaborative project that helps women complete their PPOs and defend their PPOs, and these are two separate projects. So we're going to be talking about how to defend the PPO through these motions to terminate right now. The other part of the project, of the Impact Project, is how to prepare a PPO. And if you'd like to stay for that second session, that is a non-litigation affidavit drafting, essentially, component of this project. And just to give you some ideas, for those of you who aren't familiar, the Impact Detroit Project was started last April as a collaboration between the Legal Aid and Defender, Dykema and Bodman law firm, and the clerks of the court in Wayne County, as well as the chief judge, the chief family judge. We all got together and realized that we could do a lot more for domestic violence survivors, and thus these projects were born. So for those Dykema lawyers who are here completing part of their litigation training component, some of this stuff may seem a little bit weird, but we have a set of lawyers here who are participating in a culmination of a several-month training program, and we have those attorneys do motions to terminate because you can really pull everything from that training experience into these motions. So I just want to be aware of the different audiences and what I'll be talking about today. So, okay. With a motion to terminate, we are going to be talking and working with victims of domestic violence. Okay, so remember, let's put this in context. In Michigan, we'll talk about this a little bit, but in Michigan, women or men who are seeking personal protection orders have the right to go to their local courthouse and seek essentially ex parte relief. In fact, it is called ex parte relief, to seek protection from violence. And they have to assert, and we'll go through this in the statute, but they have to assert one incident of domestic violence, of unwanted touching or acts, and assert that they are afraid. They don't need a police report. They don't need a medical report. But we're dealing with a situation where these women are, mostly women, are in an extreme state of crisis. And they're not going to present to you, like your business clients may, the facts in a linear fashion. And so what's important for the attorneys to know is that you're going to have probably 1 or 2 hours to prepare and to gather the essence of what's going on, what are the dynamics of the relationship that give rise to the legal remedy that you are seeking to protect for your client. So what I want to talk to you about are those dynamics that have been well researched and discussed over the years. And we'll kind of weave this into our training throughout, but I want you to be aware of these tactics. So if you understand the tactics, you can be an effective advocate is essentially what you should know. So one myth about domestic violence is that it's all physical. You're going to always see a woman who has a scar, a bruise, a bump, a hospital report. She's going to say, I was raped. That's actually not the case, okay? More often than not, you're going to see, he pushed me to the floor. He came at me with a knife. I had a woman actually who's a lawyer right now who said her husband exposed him to her. And I said, well, why is that threatening? She goes, well, because he's done that and then forced me to have sex with him. And so remember that so when we're looking at this this dynamics chart, you'll see that the physical and sexual violence are on the outside. And what we'd like to envision there is that the physical and sexual violence kind of keep these tactics and make these tactics very effective at keeping a survivor in a battering situation. Okay? So that first example about the exposure is, really using male privilege, essentially, exposing his parts to her as a way to intimidate, harass, as a way to anticipate further sexual violence against her. So, but if you just said he exposed himself to me in an application, that doesn't really mean much, especially if they're a married couple. I mean, of course, they're going to be intimate. But you need to give that context of why that dynamic is in fact threatening and makes her fearful. So we want to look at all these tactics, as different tactics. We'll start from the top there, using intimidation at the noon hour there. This is a huge thing. I always ask my clients, does he ever call you names? Does he threaten you? Does he try to intimidate you? Words actually matter. When someone's looking you down and, looking you straight in the eye and saying, I'm going to kill you, it's different than saying, oh, man, I'm going to kill you for, pushing me into the pool. It's a totally different context. And you need to be aware of those contexts when you're talking to your clients, okay? Smashing things, abusing pets, displaying weapons. There, in Michigan, and in the history of this project, we see a lot of brandishing weapons or leaving the weapons on the table. Again, that means nothing without the context, prior context. So I always ask, she says, oh, he leaves his guns on the table. Well, that's certainly not threatening unless you knew that, in the past, he had pointed the gun at her. So my next question in interviewing that client is, well, why is that threatening to you? Or has he ever threatened you with the gun? Has he ever pointed the gun at you? Then you can get some context for that very prominent placing the gun on the table because she's anticipating what is next, okay? So intimidation is a definite tactic that you need to be asking about and being thoughtful about. So it's not just looks, acts, and gestures. It's the looks, acts, and gestures in the context of the abusive relationship. Using emotional abuse. This is also a really big tactic that you want to be able to exploit in your hearing. Putting her down, making her feel bad about herself, calling her names. There's lots of, or accusing her of a mental illness. That's another favorite. I have a client right now that was just placed where he wrote in his response to pleadings that she was bipolar and that she was not to be credible. She was not credible. So I said, well, are you bipolar? Have you been diagnosed with bipolar? No. Have you ever been diagnosed with bipolar? No. Have you ever sought any treatment at all for a mental health, problem? No. So I said, would you have any friends or family that testify? Of course I have people who can testify. But that is a way, telling people that you're bipolar is a way to exercise emotional abuse over someone, especially if you don't have, bipolar disease. Lots of name-calling threats, swearing at them. These are all really important questions to ask your client if those are happening to her. Mind games, humiliating her. A lot of this also comes up in social media. So if a woman is on Facebook and her partner has the passwords, very frequently they will post things. I had a client once who posted that she had, certain sexual preferences on her Facebook page. And so her boyfriend posted, something explicit about her sexual preference as a way to embarrass and abuse her, really. Only once one of her friends saw it in their feed was she able to go in and take it out. But again, these are things that, without asking the question, you're not going to get the full picture. So make sure you're asking about emotional abuse when you're interviewing your client. Using isolation is a huge thing. This is very, very easy to identify. So questions you want to ask are, can she work outside the home? Has she been prohibited from having a job? Is she able to visit her friends and family? Does he text her, excessively to find out where she is? Oh yeah, my phone blows up if I leave for 5 minutes. He doesn't know where I am. Accusing her of having an affair. That's one of the other great ones. I'm following you, or I'm tracking you. I'm, putting a thing on your phone because I think you're having an affair and I don't trust you. I also tend to ask right now, especially with the increase in technology, is, do you know if, your partner has, is savvy on the phone? Because the phones can start transmitting, location information. Even all iPhones really can do that without you, knowing that it's being done. Anything worse. So I always ask, do you, is it possible to change your phone, change your number? Minimizing, denying, and blaming. This always happens. It's like the first defense out of the box, especially in the motions to terminate. She's totally lying. It never happened. Expect that. When we're talking about when we file the motions to terminate, when the respondent files the motions to terminate, the only thing that he'll say is it never happened. So if you don't get the application or the motion, the actual form motion, which you probably won't, I'll show you what it looks like in a minute, you can just assume that he totally denies it. Otherwise, he wouldn't be filing the application. You certainly want to ask the client what they're going to say, but minimizing, denying, and blaming, or she caused it. She was arrested for domestic violence. These are all things that you want to check with her. And if she has been arrested for domestic violence, you want to do some quick assessments. What happened with the charges? What is the size differential between the parties? I had a client yesterday who called seeking assistance, and she had been initially arrested, and I said, well, what's your body figure? So she said, I'm 5'2", 120 pounds. I said, well, what's his size? 6'1" and 280 pounds. Okay. So very interesting that she was arrested and he was also arrested, and no surprise that the charges were dropped against her. So we can expect in that hearing that he's going to, immediately say she was arrested for domestic violence. And then the advocate can say, Your Honor, look at the size differential. The charges are dismissed, but, it's even just looking at the size between the parties, she's probably not the aggressor in this situation, just using that alone. And then you can also reference the other tactics that are actually ongoing. Has he ever felt coerced, threatened, abused, or isolated? Probably not. And then you can start weeding out who is actually the aggressor and who is actually the victim. Using children, I hope this is obvious, but anytime, there's children between, in an abusive relationship, children are almost always used. Attacking the mother in front of children is extraordinarily abusive, and in fact is a factor actually in making child custody decisions. So Michigan actually has a rule that weighs against the batterer if the abuse happens between the couple in front of children. So using, that's a huge factor, and if you have kids, you always want to ask, have the children ever witnessed it? You absolutely want to raise that as a factor, because when you're dealing with a PPO judge who's actually in the family court, he or she is going to want to know that, because it's very important under Michigan law, okay? Threatening to take the kids away happens all the time. Using male privilege, this is kind of more traditional domestic violence. We don't see a lot of this, treating her like a servant, making all the big decisions, acting like the master of the castle. I've seen, less frequently now I see, kind of what you see on the TV. Men being served their dinner and then they throw the dinner, across the wall and splatters all over, breaks the plate, making a big scene. This is what I would call using male privilege. But again, if there's like assaultive behavior that is not necessarily directed at her, it's still relevant, because again, it's meant to intimidate, harass, and use the male privilege against survivors. Economic abuse. This is a huge thing you want to be aware of. Economic abuse, big time, especially if the woman has some education or has some economic power, preventing her from getting a job, or even better yet, harassing her at the job. I've had women who have been fired from jobs because the boyfriend keeps showing up, and it's a deliberate attempt to sabotage her ability to earn a living. And this is also using economic abuse as another good reason and a defense to a judge who asks you, why is she staying? And we'll talk about why is she staying in a little bit. But if you have that, explored with your client, if you've explored that issue with your client, what, are you working? What are you doing? Does he allow you to keep your paycheck? Does he prevent you from keeping a job? Does he prevent you from working overtime? What about bank accounts? Do you guys share bank accounts? Do you guys have access to shared bank accounts? Does he, itemize your spending in a way that seems unreasonable? All of these things are super important to ask about, again, because you can understand why why one incident of domestic violence is going to allow the batterer to hold the bank accounts, because she doesn't want to get beat up again. She doesn't want to get beat up again. She wants to just be compliant so that she's not subjected to another assault, another rape, okay? So this is a really important question and helps shed some light on why, quote unquote, I hate this question, I'll explain why in a minute, but why she stayed. Using coercion and threat. Committing suicide. This is coming up more frequently. All the battering situations are always different, but everybody likes to threaten to kill themselves. I'm going to kill you. If you leave me, I'm going to kill myself. That's always a threat. Oh, I've got a gun. I'm going to point it at myself, and I'm going to kill myself, if you leave me. Always ask, especially if there's a gun in the house or he has guns, has he ever pointed himself, you, whatever. Especially if the couple shares children, you don't want the father or parent of your child to be dead, regardless of how bad they are. And that should make sense. That's clearly coercion and threatening behavior, and you want to make sure that you know that. Reporting her to CPS, another very common tactic. If you're mad at your partner, you can always call CPS and guarantee her some harassment, especially if nothing's going on, and that could be a defense. If you've called CPS, that's the first thing out of their mouth. Not only do I deny it, but I've called CPS on her, and we're waiting the investigation. So, you want to be aware that that's actually a tactic and be able to call it that in your defense. Your Honor, this is a tactic we've used. She's called CPS 5 times. They've all been unsubstantiated. I anticipate that that's what's going to happen here. We've already reached out to the CPS worker, and they've said there's nothing going on. Very important to be able to dispel that issue or to put it in its proper context when you're like, oh, CPS has been called. What's going on, just be aware that CPS can be called at any point. And making her do illegal things. Not as common, as we see it anymore, but the only time that we actually see that is when, you've got that I see it usually is when they're, when the respondent or the batterer is using drugs, like using illegal drugs, and they will encourage the survivor to use with him. So, again, as part of the defense, she's a drug user, and she's been, whatever. She's been using with me. And you want to make sure, if there's no other physical violence, then clearly she's just cooperating with, using behavior. But if there's physical violence that's been, part of the relationship or sexual violence, again, use that as a way to say, Your Honor, she's been beaten several times, threatened, at point-blank range. The fact that she, the client admits that she's used, cocaine with her partner, but, she's concerned about the response. If she says, no, I'm not going to use cocaine, what is he going to, backhand her, as he's done 3 other times? Again, just be prepared to think about it in that context from, try to step into her shoes and think about why she's doing what she's doing, why she's using the drugs, why she's allowing him to pull a weapon on her, and why she's staying if, in these circumstances. Maybe they have a kid together, maybe they have economic, shared economic situations, maybe she's unable to get a job to because, he spread lies about her. Okay, so those are the tactics, and at the center of that wheel is the power and control. And this is getting a little theoretical on you, but I just want you to be thoughtful about, when we talk about what's really going on here, this is really about power and control and trying to exert power and control from one person to another. That's reinforced by all of these tactics around the wheel, and then even one incident of physical or sexual violence can encourage and allow all the rest of these tactics to flourish in a relationship. So it's really important when you're talking about a motion to terminate that you're asking the client about all of these tactics. So if you only have one incident of physical violence, you can really do a 3,000 times better job if you're able to say, Your Honor, yes, 3 weeks ago he pulled a gun on her and she's terrified of him. But why is she so terrified? Because he's been preventing her from getting a job, he's threatened her with the children, he's threatened to kill himself, he's not able to get a job. If you're able to articulate all the rest of the circumstances, now you've just taken an isolated incident of pulling a gun on somebody, which could be a joke, right? I mean, it could be a joke, who knows, into what is a very serious and highly lethal act of violence against from one person to another. Okay, so be aware of that. Also, when you're talking, we'll talk about this a little bit more, but when you're talking about sexual violence, especially those who are guys in the room, I've asked that, and just be thoughtful about this and considerate, and I know you guys are considerate people, because I know Bryce is. I anticipate that you are just by being here. You want to be very careful when you want to preface your comments about sexual assault with, listen, I know we've just met. We're not going to have a ton of time to kind of ease into this relationship, and you want to acknowledge the awkwardness up front. So say, listen, I'm going to be asking you some really challenging questions, and in order to provide you the best defense possible, I need you to just be frank with me and understand that I've gone through this training, I understand what's going on here, and I just need to know the answers to these questions so that we can provide the best defense possible and keep your PPO in place. And then you can say, I've asked you a couple questions about the physical violence. I really need to know if he's ever forced you to do something sexually that you don't want to do. I would not put a label on it. I wouldn't say if he sexually abused you, I guess he raped you. Just simply asking, if he's made you do something you don't want to do, yes, you can assume that that's plenty of information to present to the court. And sometimes they'll elaborate. They'll tell you, well, I had a client where I started with that question, and then she said, yeah, it's been really bad. And then later I asked her, well, what was the worst incident of domestic violence that you experienced? And she goes, well, actually, when he last raped me, he literally held me to the bed and penetrated me. I mean, I'd known this woman for like 20 minutes. And when they say, when they say something like that, it can be jarring for you. But and I think you just need to acknowledge it and just say, wow, that's awful that that's happened to you, and move on. You don't need to counsel her, oh, I'm so sorry for you, whatever. It doesn't. We're having a professional relationship, and I think that's all you really need to say. That's really terrible. Acknowledge it and move on to your next question. This section I would encourage you to come back to. I'm going to skip it today because we don't have a ton of time to cover it. But this is about the neurobiology of trauma. There's a movie in here that's put together by a guy I personally know who is awesome in person. His name is Christopher Wilson, who deals with the neurobiology of trauma in survivors, especially domestic violence survivors. And I came across him when I was doing some work in human trafficking because I was having trouble understanding what was going on with my clients. And he has done a masterful job of explaining what how traumatized victims interact with professionals. And if you want, this is about a 10-minute video, and I encourage you to come back and watch it because it's just that good, so that you have a better idea of who you're talking to. Okay. All right. talked a lot about domestic violence. I literally have summarized, when I first started volunteering, 20 years ago with domestic violence survivors, as a non-lawyer, I literally had to spend 40 hours understanding all the dynamics that I just covered in 20 minutes. So, my DV friends who are out there who do a lot of work in this area, we're all on the same page. More can be done in this area. But in the interest of brevity and time, I'm going to move on. If you guys have questions about the dynamics of domestic violence or something doesn't seem to make sense, just ask me. Sometimes it just doesn't make sense, even now, 20 years later, for me. So I'm happy to offer as much context as I can. Personal protection order, what is it? Okay. In Michigan, it is injunctive relief. It's issued by the circuit court, and there are two types of PPO. The domestic PPO, when you talk to the court, they're going to be talking about a domestic PPO and a stalking PPO. And I always said, well, what the heck is a domestic PPO? That doesn't make any sense. What that is where the parties have an intimate relationship with one another, either a dating relationship, a live-in relationship, or they share a child together. Okay? So that's your first component of what is a PPO. A stalking PPO, you don't need the component of the intimate partnership. Think of, Angelina Jolie has a stalker. I mean, she was in People magazine. There's a stalker. So it could be a stranger that is making unwanted contact. So 9 times out of 10, I would say 9.9 times out of 10, cases that come out of this clinic are of the domestic type. Okay?
What if you used to have an intimate relationship that you don't?
Domestic. Oh, I'm sorry. The question is, what if you had a prior dating relationship, like 2 years ago or a year ago, you got broken up, you no longer are in a relationship, you're still able to get the PPO? Good question. It's a domestic PPO, it's not a stalking PPO. If there's a former or current intimate partnership, you get the PPO. Okay, again, here's the domestic PPO. Housemates, be careful about housemates. I would say that I believe that the statute actually says housemates, but you want to make sure if you have that fact pattern, which you probably won't, but if you do, make sure you're reading the statute and making sure that you can actually make that allegation and bring it to the court's attention, because we don't have housemates seeking domestic PPO that often. All right, so you have to have a type of relationship that restrains the conduct that's explained in that statutory type. I think I have the statute, and I'll walk you through. And it only requires one incident. Okay? So don't get hung up on, he only pulled the gun on you once, or he only backhanded you once. It's enough. It's enough. And the fact of the matter is, guys, if you can effectively interview your client, you will discover, as I have over the 20 years that I've been doing this work, that there are other tactics and things that exhibit and support the existence of a violent relationship or an abusive relationship. So don't give up if you feel like your client is not, it doesn't happen that you just pull the gun on him and that's the, I'm going to kill you, and that's the only thing that's ever happened between the parties. It just doesn't happen. And if your client isn't telling you, you're not interviewing them effectively. Okay. Oh, here's the statute. Okay. So A through J. All of them, I don't think I have a pointer. Oh, yeah. All right. I have a pointer. All right, so these are the restrictions: entering on the premises, attacking, beating, molesting, wounding the named individual, threatening to kill or physically injure the named individual, removing the minor children, except as otherwise ordered, purchasing or possessing a firearm. These are the things that you can restrain someone from doing. We'll talk about firearms in a minute. Interfering with petitioner's attempts to remove personal property, interfering at the place of employment. We talked about that as a tactic. Or education. I had a client like a year and a half ago who was a PhD student over at Wayne, and her lived-in boyfriend sabotaged her thesis multiple times. And the only way that we were able to persuade the judge that in fact, because it was like, oh, the computer got coffee spilled on it. Oh, the thumb drive got erased. Oh, I sold your iPad with all of your data on it. Oh, was that those were all tactics that we were able to explain through the physical assault. He also literally threw her textbooks at her. And we were able, there was effective evidence to be able to, in fact, force the PPO, even though we had to go to an evidentiary hearing. So interfering with education or educational relationship or environment, okay, really important, if you've got that interference going on. Having access to information concerning a minor child, engaging in conduct as prohibited. This is stalking, any kind of stalking behavior. Any other specific act that interferes with a personal liberty and causes a reasonable apprehension of violence. I love that category because domestic violence abusers are very creative in their tactics. So if you hear something that's like wild and oddballish, don't be afraid to say, and by the way, you can't do X, because there's a line for that on the form, okay? So just be thoughtful about that.
Could you explain H? Having access to information. How does that usually come?
So if we want to explain what H says, having access to information and records concerning the child of both petitioner.
I just don't understand how that's that conduct.
Right. So if the batterer has been ordered to stay away from the petitioner, the survivor, very often a respondent will go to school and ask for the new address of the child, so they can discover where they have now relocated to. That's very common. So if you have, especially if you have like a pursuer, I call them, somebody who just will not give up, just chasing them all over town. I would say that, and by the way, if that's actually happening in your case, know that the possibility of more lethal behavior is actually, the Department of Justice has a ton of statistics on particular tactics that are indicators of more lethal acts of violence than others. A pursuer is one of the hallmarks of lethality. So that's where if your client expresses a concern, listen, I really need him not to know where I am because I'm now in a special safe hiding place, then you can trigger Section H if you share children together. Because otherwise, under the law, if you are if you're on the birth certificate or you're married, that father has legal authority to that child and all of the information related to that child, okay?
So nothing has to happen for you to get the PPO under H. Because
you have to check the box.
You want to stop them from getting
Yes, you have to check the box. You have to check the box and explicitly ask for it. But you'll see she has to check the box. So when you get her PPO, the ex parte order, you will see whether that box is checked or not. And it won't be checked if they don't have kids together. It will be checked if they have kids together and she has this, concern that he's a pursuer. Okay? All right, I just made a figure here. Oh, that's distracting. Okay, stalking PPO. Just real quick, you're probably not going to have these, so I'm just going to whip through this. Restrain specific conduct not defined by the relationship. Stalking behavior is willful course of conduct. Now, if you contrast that from the domestic PPO, which is this is a course of conduct, 2 or more incidents that intends to harass and cause a reasonable person to feel harassed. All right, so perfect example. I love this one. Woman is at a yoga studio and she's very svelte and fit, and she does all these crazy yoga poses that makes this guy who's at the yoga studio go nutty. And he starts contacting her on the internet. And these are unwanted contacts. And he continues to pursue the yogi. It's kind of a funny example, but it's actually very serious when you're not interested in being pursued by, your fellow yogi master. That's stalking. That's an incident of stalking, okay? So you have a willful course of conduct that is trying to intimidate or harass, and in fact does cause that harassment, okay? You're very likely not going to have these, by the way, in your motions to hearing. Go ahead.
You
Oh, you can stalk, yes, yes. And you'll see there's some statute. You can't, the question is, can you stalk someone on Facebook or any kind of electronic media? Through email, through cell phones, any kind of electronic media is all part of it. I think I actually talked about that right next here. Internet stalking is defined at that statutory section, and it's, again, two or more, acts with continuity of purpose. Again, in that Yogi example, this guy was seeking out, a personal meeting with this respondent, and it was not wanted, and they were, continuing to pursue. All right. Prohibited conduct. Again, we went over those. You'll see what you can prohibit. There's a catch-all, so don't be intimidated to ask for what you actually think your client needs. Okay. Very quickly, and we're going to focus on this for those of us who are going to be here for the second half of the training. We're going to talk about this in more detail, but process to obtain the PPO. All right. We're going to move through this very quickly. Mostly there's a pro se process unless you're a participant in the impact project that some of us are here to learn about. And mostly the volunteer lawyers enter once the PPO has been challenged, okay? And we'll talk about that, but you don't really need to know a whole lot about the process. Very involved, and if you want to learn about it today until 1:15. Filing basics, you use SCAO form. They usually seek ex parte relief. The burden is on the petitioner. If denied, the court must issue a written order, and the petitioner can request a hearing. Okay, this is what the petition looks like. Do not get excited. If you do not have when you get called to do a motion to terminate, you're like, I need a file. That's what happens. That's like big lawyers, I need all the papers. That's what big lawyers think, big firm lawyers. Maybe even small firm lawyers think this, but all I have experience with is big firms, and they're always like, well, where's the motion? Where's the petition? Well, wait a second. This is all it is, friends. Okay? And it's not that great. It's not that great a shape. Literally, look at this section E, you guys. I need a personal protection order because it's got like what? Not even an inch of space, okay? So don't get excited that you don't have anything more, okay? Just talk to your client. You're going to have way better information from talking to your client than what will fit in this little bitty space here, okay? And that F, you can see, these are the things that she's asking for, and lo and behold, they mirror the order of the statute. So if you read that, you're like, oh, it goes, A is A in the statute, B is B in the statute. So just watch for that. That's the petition. It's not going to be anything exciting. Also, if you do have the pleasure of receiving a copy of the petition, which you probably won't, but if you do have the pleasure of reviewing this, note if the client has not put her address in here, because otherwise she has the right to protect it, and you want to keep it out of the record. Most of the clients that I've seen in Detroit and in Wayne County, they don't care because the respondent mostly knows where they are anyway. So they're like, I don't care. I don't need to cost an issue over that. Okay? All right. This is another straight up form of it, and you don't need to look at that. Okay. Once you receive an ex parte order, the PPO must be effective for 182 days, which is over 6 months. The service of the ex parte order must be served but can be enforced without service. That's what that means is, batterers love to evade service. They love it. In fact, I think it's a tactic of abuse to use the legal system as a tactic of abuse. So if your client's like, oh, you never got served because you keep evading service, oh, you've got another tactic there that you can mention to the court. We all know that service is not going to be evaded, and you can just go in for alternative service. So if he's being a jerk regarding service and he thinks he's being cute, I would absolutely raise it to the court because it is, and call it what it is, which is a tactic. But guess what? The law does not see right through that, and it can't be enforced without service. So, she gets the PPO today, and later tonight decides to, knock on her door and, try to break down her door or what have you, or come through the window because she won't open the door. All she has to do is enforce the order, which is called the police. Okay? Once the respondent does clue in that there is a PPO, whether through actual or legal notice, he has 14 days to file a motion to terminate. Okay, notice 14 days of service or actual notice of the PPO. Again, this is the Michigan legislature being smart and getting smart on respondents who are being too cute about PPO. So especially, I love this. They're like, I never got service, so you filed your motion. So, like, what do you talk about? Of course you know about the PPO because you're filing a motion. You get very cute about those things. And I would tell you, the other thing I would tell you about this is if the motion is filed outside of the 14 days, can you actually try to kick it on procedural grounds? Yeah, you can try, but it probably won't work because you're usually not represented by counsel. Okay, so yeah, you can try. You can just make a note of it, but mostly they don't care. Okay, this is what we're looking at here. Again, notice how similar it looks, A through J, to the petition, but this is actually your order. And I also don't want you to get too excited about if you don't get this from your client. You might or might not get it, but look at how hard it is to read. Believe me, I promise you, it's harder to read in person because it's filled out, it's a triplicate, and it's a terrible copy, I promise you. So don't get hung up that you don't have the PPO. All you really need is to talk to your client, okay? Again, let's just walk through the form very briefly. You'll see that there is, once this is signed down here, this will say, who is entering it in, and this is how long it's effective until. But you can just read through. You can see what he's been restrained to do. Okay. Another big one you want to know is if he says restrained from purchasing or possessing a firearm. Just to give you a little quick insight on that, because I've had a lot of firearm cases recently. Look at that handgun. Handguns are like more prevalent in Wayne County, as I know, and everybody seems to have a whole arsenal of handguns, at least respondents that I've been in contact with over the last several months. And when the order is served, and they are, as I understand it, most police officers, they will literally come in and take your gun, which is not a happy day for a respondent who's, number one, learning that their girlfriend is leaving them or has already left them, and then their handguns are being taken. That usually sucks. And so they can be really upset about this, and it usually is one of the big reasons why they file PPOs. Okay. Or file for responses because they want their guns back, believe it or not. And some of the guys actually, have the audacity to say that, like, I'm not going to do anything, give me my handgun, which is funny, but I think, but anyway, so this is a big issue. If the guy uses handguns for work, and I mean, like, it's required, you're required to carry. I had a guy once who was I was going to say drug dealer. He really is a drug dealer. He actually sold pharmaceuticals to hospitals in Detroit. And his claim to me, I'm not kidding you, because he had also an arsenal, he's like, well, I don't feel safe not carrying my handgun because I'm carrying pharmaceuticals and I could be robbed at any moment. I said, so he's trying to trigger the requirements under this statute, but, which require a higher level of proof to keep the handguns away. And I'm not going to cover it because if you get the case like that, I'll flag it for you and we'll talk about it. But just know that it has to be like he's a CO, he's a police officer, or something else that requires handgun use, security officer, whatever. Not the drug dealer who's, selling pharmaceuticals. And maybe some of us will say that he is a drug dealer. But anyway, so handguns are a big deal, and just know that's a big reason why people challenge their PPOs because they want their guns back. Okay, couple things. No mutual PPO. Now, Wayne County is really good about this. You don't usually see mutual PPOs, but just know that those are prohibited. If you get a lawyer who's representing the respondent and says, I want a mutual PPO because they both need to stay away from each other, your immediate response should be, the statute does not permit for mutual orders. And there's a reason for that, because what the Michigan legislature has decided is that there's one person who's the assailant and one person who's the victim. And if you haven't been able to decide who that person is, call me up, and I'll help you try to pull out the facts so that you actually know. And I'm not saying that women are never the assailant, but I'm saying it's rare. And 20 years of my experience has shown that, and the research bears that out. But I reserve the possibility that sometimes women are the aggressor. I personally have not seen them, okay? So no mutual restraining orders or PPO. And actually, I had a Freudian slip there because I was also going to talk to you about restraining orders. Another favorite response from respondents, especially if they're represented, is let's have a restraining order. Or even better yet, let's have a mutual restraining order, a civil restraining order. And for those of us who practice, commercially, like, who do this, for businesses, we're very familiar and comfortable with what that is. But also should be familiar and comfortable with the fact that that is required a trip back to court. You have to file a motion to show cause to enforce that, okay? Your client does not want to have to see you again, nor does she want to have to enforce the PPO again by coming back to court. A PPO is enforceable immediately by calling the police. PPO is put into place and put on the lien system with warrants and other, bad guy information, okay, and gal information. So you call the police and say, I have a PPO against Joe, and he's knocking on my door. The police will come out and arrest Joe on the spot, even if Joe's just sitting on the porch, because it's prohibited contact under the PPO. If you say, I have a civil restraining order against Joe, and he's not supposed to be on my property, the police cannot do anything. The police require an order from the court saying, you can be arrested. It's two different orders. It's two different remedies. A restraining order is not the appropriate remedy for an intimate partner, abusive intimate partner relationship. So never, never, never consent to that form of relief, because it's just going to require your client to go back to court. I would rather have you lose the PPO and have her come back on a new incident of domestic violence than for you to agree to the restraining order, because it's not an effective enforcement tool for your client. Not today, not tomorrow, not in the next 180 days, okay? And never a mutual order. Okay. Any questions about the restraining orders, PPOs, mutual orders, all that? Okay. Okay, this is 201 PPO time, pre-existing parenting time orders. If parties are divorced, they have a formal relationship, they have a parenting time, or maybe they were never married, they have a parenting time order. What happens then? The PPO supersedes any existing parenting time order. As a practical matter, however, so your ex parte order will show if it's been amended at all. I would say 30% of them are, 70% of them are not. So meaning the parenting time order is not affected by the PPO at all. Like, it's not mentioned, which is okay, all right? If you have an ex parte order that suspends parenting time, first of all, a flag should go off in your head that the court has made a determination that this is a higher lethality case, okay? Because 9 times out of 10, survivors will not ask that parenting time be suspended because it is on paper and they don't want their partner to know that they are seeking this order, okay? It's a fairly risky thing to do for many survivors. Not all survivors, but for many survivors, to ask the court in writing to terminate parenting time will really set up a whole new level of assault and retaliation. And so the first thing that most of my clients will say, or the clients I've interviewed will say, is, I know parenting time is suspended, or I know it's supervised parenting time, but I want you to know I did not ask for that. And what you try to tell you is, you ought to say that on the record in front of the judge so that your respondent hears it loud and clear that this was not part of it. That's part of, like, how you protect her from future assault. That this was a judge decision, not your decision, her decision, okay? If that's what's happening. All right. So if there is pre-existing parenting time order, it takes precedence. If the client wants to amend the parenting time to be supervised or to change the drop-off spot, and you want to talk about that, all you have to do is say how it changed. I mean, there's no magic to it. You're not going to change, like, support or anything else. Just ask for what you think your client needs and wants, and go for it, okay? All right. Streamlining enforcement of the PPO. Okay. This is just, everybody talks about this, but just, note these rules. When you first get your PPO, I'm going to ask that you review these court rules and these statutes. Rule 3.700 series is all about PPOs, and I'm going to tell you, you're not going to want to read it, but I'm going to tell you you've got to read it. Just read it. You're going to know more about PPOs than anything I said today, and more importantly, what the judge will know about PPOs. So just read this section. And then also read the statutory section that creates the rights that you are seeking to protect. This is enforcement. I've already told you how you enforce it. The client's going to ask you, call the cops. That's it. Call the cops. Tell me you have a PPO. They'll come out and arrest him. Okay? Here I call the police. Call the police. They will usually not necessarily in Detroit proper, but they will usually arrest and hold them for a period of 24 hours to 72 hours. And then they will either charge with domestic violence, or the prosecutor in that city or county will file a motion to show cause. Again, it's right there. You're not part of that process, okay? But this is just part of how you get a violation, how you trigger a violation. Jail time up to 93 days and monetary fine up to $500. This was passed like 20 years ago, and this actually was something serious. Clearly, it's not that great. Okay. All right. Motions to terminate, modify. All right, I've given you all this background, so now you're ready to actually take your first client. What do you need to do? And no. All right. Remember, I told you that they have to file their motion to terminate within 14 days of receiving or they having actual notice. They also have 14 days to respond to set a hearing date. Okay. So you're going to have a very short prep time unless the court has extended it for some reason. I have actually one client that went to a hearing this week. We couldn't place him with a lawyer. The guy represented, but he needed a translator, and so they adjourned it for 2 weeks. Never happened. So if you want this client, let me know. She's actually a great client and she was actually one of the examples I used today. Great client is an easy win, but she needs a lawyer. So they will. You get 7 days notice. It's usually less than that. And if you have a handgun just for the job, it's even less notice. Just know that. And so when you get an email from me, when you add to the listserv, literally, if you say, oh my God, I only have 5 days. Well, most of these cases you're only going to have a couple days. And if I have 2 weeks, it's like, woo! You're really thrilled, okay? But the great thing about this, guys, is you really don't need that much time, okay? You're going to go through the interview. Right now it takes me about 20 minutes, but let's give you an hour to interview your client. You're going to have enough information in an hour to prepare for this hearing, okay? You don't need to meet with her in person. I never meet with my clients in person. I do it all over the phone. If you feel more comfortable meeting with them in person, fine, do that. But I don't think you need to do that. So don't be intimidated by the short prep time, because you really are not going to need a ton of evidence or a ton of information that your client isn't able to give you over the phone. All right? Assume that the motion, I already talked about this, assume that the respondent's motion will not give any details. He'll just deny it, or say he wants his handguns back, or say it's all bullshit, or that she's a drug user, she's a CPS violator, whatever. I mean, no thing. Just assume, you could ask your client, what is he going to say? It's probably going to give you more information than what's in the motion. So don't bother yourself and worry yourself about getting a copy of it, because it's not going to be that detailed. Witnesses and evidence. Couple things. Police cannot deny for lack of police or medical report. Don't let stereotypes about domestic violence get in your way. Okay? You're not going to have a police report. Some of the most significant domestic violence that I've ever seen, where women have been killed, maimed, lost their arm, lost their foot, whatever. Never a police report ever, but yet the foot is still gone. So really, women do not call the police on their survivors. This happens for their respondents. It happens for a lot of very legitimate reasons. Number one, her own safety. She cannot, if she's worried that guy is going to, he just backhanded her, and now she's calling the cops. Hello, there's a response time, and in some of our cities, the response time is hours. That exposes her to hours of additional abuse if she feels like that is going to be an issue. So she might not call the cops for that. Another more significant problem is she knows the police are not going to do anything. And this is kind of sad in 2015 that, that I was talking about this in 1993 when I first started learning about domestic violence, that police do not arrest when a woman is saying that this guy beat me up, when in any other circumstance in our life, if you made an allegation that someone was beating you up, the police will automatically arrest. But just because you're living with them or had a dating relationship, that somehow that's going to be a different circumstance. Unfortunately, that is actually what happens here, especially in Detroit. The system is overwhelmed. They don't arrest. They won't arrest. So you're not going to get someone to call the police because they know that they're not going to get a response from the cops, and then they expose themselves to what? Additional violence. So, and especially, same thing goes with medical reports. Remember, literally, I'm exaggerating about the cutting the foot off. I've never had a client have her foot cut off, but I have had clients like drag some cars, run over, whatever, by their boyfriend, and they absolutely deny that it is, that it's their boyfriend that did it to them. And you're like, you're crazy. Actually, no, she's not crazy. What she's actually trying to do is prevent further abuse and harassment by her partner, who still is in all of her business. Maybe it's still the father of her children, and she has a year-long custody battle in front of her, and she knows it. So you may be lucky, and she may confide in you that, he did drag me from the car, or rape me on top of my car. It's another example that I've heard repeatedly. But she is not going to go to the doctor and say, guess who gave me this black eye. It's not going to happen. Okay, so don't expect that you're going to get a doctor report that's very nice and neat, and it's going to say, response or petition her eye was busted because her boyfriend did that. So it's not going to happen, and just know that that is a protective mechanism more likely than a credibility issue, okay? And that's why it's not required, and that's why it's part of Michigan law. Think about other evidence that you might have. Very frequently today, we see a lot of bad texting or batters will put this crazy stuff in text. Like I'm going to kill you, and then string of expletives. I'm going to come over, and I can't even repeat some of it. It's unbelievable stuff I've seen on text. If your client has that, have the client print it out, or better yet, just keep it on her phone, and you need to carry the phone in for her. Remember, you're the lawyer. She is not. She's not entitled to bring her cell phone in, but you can. Carry 5 phones in. I don't care. You're entitled to bring them all in. You want to talk to the judge to make sure that they will be responsive and interested in receiving text. That's what I would say that in Detroit they're fine with it, but if you're in Oakland County, they want you to know if you're going to be presenting evidence that's on a cellular device. Cross-examining your batterer. Never done it, would never recommend you do it. Which makes it kind of easy for you, right? Why don't you do it? First of all, you haven't deposed them, you don't know what he's going to say. And the first, rule of trial advocacy is, don't put someone in the stand that you don't know what they're going to say. You don't know what you're going to say, and frankly, he's probably going to deny everything anyway. So don't do it. You really don't need to. Instead, focus on your client's story and her situation. Okay, it's very basic. 3 things. Nature of the relationship, what has led her to receive a PPO, and why she's afraid. That's really what are the 3 things you need to articulate. It's your burden to defend the PPO in face of a motion to terminate. You still have the burden. You will continue to have the burden. Just say those things. You don't need to deal with, you're not going to, I wouldn't raise anything about I need the handguns, I'm not on bipolar. I'm not bipolar. I wouldn't even raise any of that stuff unless and until the respondent raises it in his opening remarks regarding why he would like the PPO to be terminated. Then I would say, go through your 3 categories of relationship, why the PPO, why you're afraid. Furthermore, Your Honor, my client is not bipolar. We have 3 people in the audience who can, put testimony on today that tells you they're not bipolar. She's not a drug addict, and here's the 5 letters from CPS that says, that have all discovered that the abuse allegations that have all been brought by his father are all unsubstantiated. Don't respond in advance to what you anticipate the batterer is going to say, because batterers love to have like a whole set of stories and lies that they have in their back pocket or threaten to use, and then kind of back way up when they see a lawyer is there, or they, I've had a client or a batterer, and he's on the record that, number one, he did beat her, but because he was high on heroin. But, okay, well, that's real stuff. Like, thank you for that. And then the judge in that case was like, okay, well, the PPO is going to stay in place then. So you don't need to say anything in response to beating up while using heroin, and heroin is not a defense to beating. So you're fine there. Expect in this court that you will be expected to prepare your client for a direct examination. She doesn't take the witness stand. You can simply turn to her and start your minion, okay? For those of you, and for those of you who are going to have a mentor attorney, you'll work with them on that process, okay? You should keep it very pithy, very short, okay? I like to focus on a couple questions as a routine, questioning. I don't even write stuff down except to know what the chronology of the facts are, because my outline is always the same. What's your relationship to the respondent? Why did you get a PPO today? What's the most serious incident of violence that you can recall that happened between you and party? And why do you need a PPO? And if there's a couple incidents within the last 90 days, the court likes to hear about the stuff within the last 90 days. It gets challenging when you have a 17-year marriage and there's like oodles of domestic violence, okay? In those situations, what I like to do is provide very brief 5-sentence introductory comments, like, parties been married 17 years. The relationship has been rife with domestic violence since the 5th anniversary of this marriage. The violence has included physical violence, sexual violence, and emotional abuse. The reason the client is receiving the PPO today is because 3 weeks ago he threatened her with a knife and then exposed her, which made her think that he was going to rape her as he had done in the past. Your Honor, my client is afraid of him. She's going to be moving towards getting a divorce, and she'd like to maintain this PPO to keep the calm between the parties as we move into separation phase of this relationship. Your Honor, I'm going to introduce my client. Here she is, and then you're going to have her repeat that statement. That's all you need. I've just met the requirements of the PPO. You could really rest on that. But the court in Wayne County generally likes to see a little testimony from your client. You don't need to get into, like, your client. Some clients really want to get into, like, he's accusing me of cheating. I'm not cheating. He's accusing me of, he's calling stuff on Facebook. I'm really pissed. She did this. He's not agreeing with me. I want to, my job, my kids. I'm a bullet. And it can be very escalated. What you need to do is to keep focused on the statute. Unwanted contact, unwanted touching, and why she's afraid. We are not going to need to talk about whether or not you're cheating. We're not going to need to talk about whether or not he's an alcoholic, unless it's relevant. We don't need to talk about anything else about the dynamics of this relationship unless it has to do with unwanted touching and contact. Okay? So you want to coach your client on how to tell the story in a very neat, confined, cocooned-like way. Okay? And that's what you'll get from your mentor lawyers, and if you need assistance with that or, want some help on how to do that, it's a little bit of an art, but remember, you're only going to have a very brief period of time, so make sure you get your incidents in to give the full context. Remember, the genital exposure between a married couple is not going to be a big deal unless you're able to say he's raped her in the past. So you want to make sure that you can get that nugget in there. You don't need to give all these details about the rape or how he held her or what he did, blah, blah. Rape is bad enough. Don't need to go into any other details. Just put it out there, okay? Thank God the courts are not, like, jerky about that. Okay, this is what the motion is going to look like, guys, just so that you know what you're not missing. The motion to modify, extend, or terminate the PPO, this is what the respondent is going to file, and you're not going to have a copy of it. Don't anticipate you're going to have this copy. No, he has this much space to say why he wants to terminate it. Not that much. You're not going to get that much information. You're not missing anything. Don't worry about not getting this. Okay? All right. This is more tips. Focus on the worst, first, and last incident of domestic violence. Don't forget to think about the power and control wheel. Consider the coercive and nonviolent tactics. Consider evidentiary issues in advance. Okay? Especially if you have an attorney on the other side. The court in the PPO court is usually very lenient about evidentiary rules. But, you know, if you're practicing, you might as well use them and be prepared. If you've got a written record or a diary entry, or, you know, check your evidentiary rules and how you have to, you know, enter those. Police records are not admissible, guys. They're not admissible. You have to have the police officer authenticate them. So even if you had a police record, it's not admissible, okay, unless you bring the police officer. And let me tell you, you're not going to get the police officer in 3 days, okay? So forget about it. Don't worry about it. It's credibility, it's testimony. Don't get all wound up about it. The only thing that I would say, if you really, really, really want to bring in evidence, and I've only done this one time, but it was effective, we had a client who had a batterer who was texting like 50 times a day and calling and hanging up, and it would call all the way through the night. And it was, and she couldn't lose the cell phone because there was a job connection or something. I can't remember. We had talked about like safety planning around it, and she was not able to do that. So he knew it, and he had her in a, she had her in a bad spot. We were able to subpoena the cell records and incoming and outgoing records within a few days. If you have a case number, which this is your case number, the PP is your case number, the PPO document is your case number. So if you have a very unique situation where the client is denying, or the respondent is denying that he's calling her at all hours a day as tactic of abuse, that can be a very effective piece of evidence. So then you have an authenticated business record that's immediately admissible without having authenticated by the record keeper, because they have like this whole disclosure on the first page of those cell phone records. And for that case, we won because we had the cell phone records, because he was, you know, there was a lot of to-do about whether he was physically assaultive of her, and the cell phone records were the linchpin that were able to persuade the court that not probably he was lying because he would have status that he wasn't sending these texts and calling, which he was. But but we were also able to lend a lot of the credence to the other threatening and abusive behaviors that he had exhibited. So that's something to think about. The question is, can you bring in screenshots of call history? You can, but they're not as effective. We've done that. I will read from the text messages. It's not as effective because, you know, then the response is always, it's not my message, they got a hold of my cell phone, it's not password protected, you know, somebody else did that. She did it. It's my favorite thing. She spoofed my number. I love that. Again, don't get caught up in the back and forth, okay? Remember to think about the context of the entire assaultive relationship. If it's the cell phones and you say, Your Honor, let's talk about the fact that he assaulted her at work. We have a letter from her employer saying that she was fired because the boyfriend continued to harass her at work. Let's talk about, you know, the children who are here today and are terrified and in tears because the boyfriend keeps, banging on the door. So whether or not he called her, or whether or not he called her a whatever, or put something in text like, I'm going to kill you on the text, which he probably did, you can almost just get rid of it. Don't even, let's talk about the whole context of what else is going on here in context of the entire relationship, whether he threatened to kill her on a text or not, or whether he sent it or whether she spoofed it, is probably irrelevant if you have these other examples of the tactics that are being used against her to exercise power and control. So that's where the effective advocacy, because that's what happens between the couple. They get like, you're doing this, no, you're not. It's a mind game. You spoofed it. No, I didn't. Safety planning, we call that safety planning is how to protect your survivor from further and future violence, okay? Just really quickly, when you are, remember when a survivor is leaving her battering relationship, that is the highest, that is a point of known danger for your client, okay? It's like, it just looks like they'll take judicial notice of it. It's like that, no, of a fact, okay? You want to tell your client that. You want to tell your client, from what we know about domestic violence, leaving your partner is the most, is a very big risky, is a very risky thing to do as far as your safety. How do you feel like he's going to respond? She knows him best, okay? We know the answer, but she knows him best. Is he going to back off or is he going to bother you? If he's going to bother you more, she might want to consider going and hiding, going to somewhere where he doesn't know. Consider shelter, and contacting shelter, and getting her those numbers so that she has those, okay? An easy gimme at a place where we have a lot of harassment is immediately following the hearing. Don't walk out side by side with the respondent. Tell the court, we'd like 5 minutes to exit the courtroom and get my client into her car, okay? I can't tell you how many times, in fact, one of the times that I didn't do it, the batterer was waiting outside, and I literally called 911 because I was like, all right, we're going back into the courtroom, we're going back to the court. He was waiting outside in the parking lot for her. She's like, yeah, there he is in the van. I'm like, turn around, we're back in. It's not worth it for you, it's not worth it for her. You should always leave first. Do not chitter-chatter outside the courtroom. Get going, get her out of there. You want to get out of there. The sheriff will escort the survivor down, the armed guy will escort her down. Do not let the petitioner leave unattended. Again, you want to ask her how worried she is about, this, but I would, as a general matter, I don't, even if he just approaches her to chat with her about, oh, kids, or, oh, really, I hope you can, move beyond this, any of these, like, passive-aggressive behaviors, need that to be avoided. So safety planning, be sure of that. Okay. Other resources for the PPO is, if I have not made any sense whatsoever and you really want to do some additional reading, or you want to do some additional reading, ICL. If you have access to ICL, they have a great section that's written by Rebecca Shemke, who helped me draft this original PPO project. Personal protection orders. There's not a lot of case law out there, guys, so don't think you're going to have cases. It's just oral advocacy. Okay? I've never, ever, not once, 20 years, 17 years being a lawyer and representing survivors, I have not once, ever, cited a case. You are not going to cite a case. Don't get all excited. You're not going to cite a case. Review all the statutes and court rules. I have cited the statute, and I have cited the court rules. So please look at those. Those are going to be your friend, especially when the judge says, oh, I want a mutual PPO. Like, oh, you are? Here's my training manual. I'm looking at my rule book, and I know that's not permitted. Here's the rule. You cannot do it. It's actually written up in the statute. So you'll have fun with that, educating your court about that. Brittany, this is an old contact. Where Brittany's gone. That's my contact. That's my internal number. If you need me, you can always call me. If you are participating in the impact project or want to continue to participate in the impact project once you're done with your litigation training, I will put you on a motion to terminate distribution list, and you will start getting emails from me. So I'm going to have everybody who's here and everybody who's out of the training. You'll start getting emails from me like as soon as today. I know I already have some clients who need help. What you're going to get from me is a very pithy response. I've got a motion to terminate on July 7th at 2 p.m. in courtroom 1801. They're all held across the street in the KMAC building. They're always there. You don't have a lot of waiting time, so when you're planning your day, I've waited like a half an hour at the most. You're not going to wait a long time for these hearings because it's a special court, special situation. There's not a big docket. It's not a motion day. Okay. So just plan that you're not going to need to reserve half your day. I would say 2 hours maximum. And then you'll get an email from me. You'll have like a few days notice for your hearing, and then I encourage you to accept them. We have great acceptance rates of these cases. I would say over 90% have been placed with volunteers just like you who don't know anything about PPOs except me jabbering on about it. And I just encourage you, for the remote 10% that we have not been able to place, I have done the interview for them, and I will give you their income affidavit as well as, a summary of what I've been able to, get from them about their stories. And it is, I don't feel like I should rotate intake so that everyone can have, mutually feel badly about cases, these 10% of the cases that we don't get to place. Please take a case. Don't be afraid. I'll go with you. These women are the most thankful pro bono clients that I have worked with. They're crying, they're emotional, they're very they're very helpful, they're strong women. They really need someone to literally stand next to them and separate them from the guy who's beating them up. And literally that's what you are. You're not only a physical barrier, but you are a legal barrier for her, and you're an authenticator. You are believing her, which may be the first person that that has done that. And you are a legitimizer. Just by being there, you are a legitimizer. And so right now our need outstrips the available attorneys. So please take a case. Don't be afraid. You're going to do a great job. You're certainly going to do a better job than if she's out there by herself. If you have any questions, let me know. We're going to take a few-minute break and start with the other training.
Hi, this is Morgan again. For those of you that were participating in the first session only, thank you for your time. And Heidi, thank you for all of the knowledge. I know both Barnett and Carla are on the line for the second session, and as Heidi indicated, we did